Good morning. Welcome to episode 54 of the Driller Newscast, a weekly update on the news and stories impacting the water and drilling industry. I'm your host, Brock Yordy, and we have an exciting episode. For the news, we're going to jump to the Department of Energy, which announced nearly $47 million in funding for 22 research projects to advance the development of new and innovative measurement, monitoring, and mitigation technologies to help detect, quantify, and reduce methane emissions across oil and natural gas producing regions of the United States. Next, we're going to talk about the Department of Interior's decision on March 13 to change the design plans for the Willow Master Development Plan in the Natural Petroleum Reserve, Alaska. Basically, the department is substantially reducing the size of the project by denying 2 of the 5 drill sites proposed by ConocoPhillips. This has been an ongoing discussion since the 1990s. For our feature story, going back to the Supreme Court, because we have the Navajo Nation versus the United States government on water rights, Colorado River Compact, and the oral arguments just happened on Monday, the 20th. But before we jump into all these great stories, let's talk some safety. This week in safety, we're going back to willful violations that get good men and women killed in the construction industry. And this time, it's a fatal trench collapse in Vernon, Connecticut. That was July 22nd, 2022. That's right. 9 months later, there's been a determination to take legal action. This is what happened. Inspectors with the U.S. Department of Labor's Occupational Safety and Health Administration, special agents with the Department of Office of Inspector General, and detectives with the Town of Vernon Police Department investigated the collapse of an 8-foot deep trench that killed an employee of a Manchester construction contractor. OSHA determined that the contractor failed to provide legally required safeguards and issued the company a citation for a willful violation with proposed penalties of $375,000. The company has contested OSHA's findings with the Independent Occupational Safety and Health Review Commission. On March 3rd, the investigation led the police of Vernon to arrest the owner of the construction company and the Connecticut equipment operator on charges of first-degree manslaughter and first-degree reckless endangerment. Basically, the quote goes like this: the contractor and equipment operator now face first-degree manslaughter and first-degree reckless endangerment charges for failing to provide legally required safeguards that could have prevented a deadly cave-in. This came from OSHA Regional Administrator Ghislaine Blanton in Boston. These arrests are the result of collaborative investigations by local and federal law enforcement groups that show OSHA will use all available enforcement tools at its disposal to ensure workers are afforded the protection provided by the Occupational Safety and Health Act. There's 39 deaths last year. I guarantee we're going to continue to see more legal action. Let's remember, slope, shore, shield. We keep talking about this as a safety topic because good men, and yeah, it's men because it's 95% of us, and we're dumb enough to jump down in that hole thinking just for a second, or we kneel down in that 4.5-foot trench and that wall is above us. And remember, if you're not moving that spoils pile 2 feet away from the leading edge, when they come in to investigate, they're going to go from the top of the pile, not the top of the ground. Again, get educated, get competent people. We cannot have the same results of what we had in 2022. It's too sad. It's too hard to think about. Let's go to another willful violation. This one, the U.S. Department of Labor finds oil and gas waste company failed to protect workers from dangers of inhalation after employees suffer fatal injury. A waste solutions company failed to protect workers from hydrogen sulfide in El Paso, Texas. federal investigators found an oil and gas company employee suffered fatal exposure to hydrogen sulfide while working near a sump pit in September 2022. The United States Department of Labor, Occupational Safety and Health Administration issued citations to the waste operator for 6 safety and health violations after the agency found the production waste facility exposed employees to serious chemical hazards. The company is located about 175 miles east of El Paso. And at the time of the incident, the employee was skimming and suctioning out of sludge water and oil byproducts from the pit. Specifically, OSHA cited the company for exposing employees to inhalation hazards, not training employees on hazards associated with hydrogen sulfide exposure, failing to provide a quick body drench or eye flush station for employees in the immediate work area where corrosive materials were present, not performing a hazard assessment to determine if personal protective equipment was needed, failing to protect employees from fall hazards of more than 4 feet, not protecting employees from contacting energized circuits. Yes, of course, that investigation went broad and wide, but think about our job safety analysis, our hazard assessments, and everything that can go wrong. Again, just because we're able to suction off the top of a pit or we can look down into that confined space, we don't know what's there. We don't know what's off-gassing. We have to protect our people with a 4-gas or a 5-gas meter, the proper training, the proper permitting, the proper competent people on site with a good rescue plan. OSHA assessed them $39,064 in proposed penalties, which are set by federal statute. Hydrogen sulfide exists in oil and gas deposits, and it occurs naturally in sewers, manure pits, well water, and oil and gas wells. This comes from OSHA, which is one of the reasons work in confined spaces is potentially dangerous. This came from OSHA Area Director Diego Alvarado in El Paso, Texas. This is a terrible loss, could have been prevented if the Waste Solutions Company had followed established safety procedures and provided federally required training and equipment. Industry. Yeah. Okay, we talked about trenches today. We talked about H2S not completely connected to drilling and pumps. But I want you to think about how quickly they are connected to drilling and pumps. I want you to think about your emergency action plan, your proper PPE, air quality monitoring, shielding. What are we doing to protect our people in the field? When you're 175 miles from nowhere, when you're 25 miles from nowhere, and the fastest emergency response is going to be 25 minutes out, think about that. What can you do on site to save your brother or your sister? We have to be a smarter industry. I'm going to keep shouting these episode after episode so that we think about it. Stay safe. This week in the news, we're going to the United States Department of Energy, which in early March announced nearly $47 million in funding for 22 research projects to advance the development of new and innovative measurement and monitoring mitigation technologies to help detect, quantify, and reduce methane emissions across oil and natural gas producing regions of the United States. Let's face it, if we're going to be able to continue to have natural gas and oil and gas drilling and these points, we have to have better monitoring so we can show that we're being responsible. Methane emissions are the second largest contributor to the climate change, and only carbon dioxide ranks ahead of methane as a greenhouse gas source. The selected projects will help to ensure an efficient, resilient, leak-tight U.S. natural gas infrastructure and supports President Biden's U.S. Methane Emission Reduction Act plan and the Biden-Harris administration climate goal of net zero emissions by 2050. Methane is a much more potent greenhouse gas than carbon dioxide, making the methane reduction a critical part of our nation's long-term climate solution. This was said by U.S. Department of Energy Secretary Jennifer Granholm. The project announced today will help the Department of Energy accelerate the deployment of technology that detects and reduces methane emissions across the oil and gas sector, our largest source of industrial methane, leading to long-lasting health and environmental benefits for the communities across the country. The Department of Energy's methane mitigation program addresses critical environmental issues associated with production, transmission, storage of domestic oil and natural gas. This project will focus on technical challenges of quantifying and mitigating methane emissions along the U.S. oil and natural gas supply chain. Think about it, everybody. We want to continue to drill. We want to continue this infrastructure. We have to be able to monitor it, hold ourselves accountable. The development and demonstration of an efficient integrated methane monitoring platform to enable early detection of methane emissions is critical. Next, let's jump to the Department of Interior, which on March 13th issued a record of decision regarding the proposed Willow Master Development Plan in the National Petroleum Reserve, which is in Alaska. Think about it. We're releasing drilling, but we're going to have a give and a take here to be able to hit net zero by 2050. And this is a good step forward in realizing the footprint and what we need to be able to do. The department is substantially reducing the size of the project by denying 2 of the 5 drill sites proposed by ConocoPhillips, which is seeking to develop oil and gas leases that they acquired beginning in the late 1990s. The company will also relinquish rights to approximately 68,000 acres of its existing leases in the National Petroleum Reserve in Alaska, including approximately 60,000 acres in Keshpuk Lake Special Area. The record of this decision denies 2 of the 5 drill site pads proposed by ConocoPhillips, reducing the project drill pads by 40%. The concurrent relinquishment of 68,000 acres by the company of its existing northernmost and southernmost leases within the Beartooth unit reduces the Beartooth unit's footprint in the National Petroleum Reserve, Alaska, by 1/3. This reduces the project's freshwater use and eliminates all infrastructure related to the 2 rejected drill sites. This includes 11 miles of roads, 20 miles of pipeline, and 133 acres of gravel, all of which will reduce potential impact to the caribou migration in that area. We can absolutely drill more environmentally responsibly in smaller footprints and hit things in much greater detail than what we have before. We can't stop drilling. We need fossil fuels, but this is the right step forward to the give and take of how we're going to do this. And you can see, as of March 20th, there were protesters attacking the climate change summit, talking about how poor of a choice this was to open up these drilling sites and moving forward. So as we start thinking about we're stopping drilling or what are we doing, you can see the Department of Energy, the Department of Interior has focused a lot of money into hot rock geothermal deep drilling, into being able to open up oil and gas sites, looking at how we utilize former oil and gas wells, abandon those orphan wells or turn them into thermal networks. It's a lot going on. We have to find the balance to be able to stop climate change, which isn't really going to be possible. We need to slow it down and be better environmental stewards. And this is a great step forward. For this week's feature story, we go to the United States Supreme Court, where on March 20th, the Navajo Nation versus the United States and the Navajo Nation versus the state of Arizona, oral arguments were heard. This is a much different case to hear on groundwater than what we were discussing with SCOTUS versus the EPA. And you can see that our justices are up on their groundwater knowledge. Groundwater is brought up several times in the opening oral argument by the representative for the United States, Lou. He says that the best access to water for the Navajo Nation would be groundwater, which would be cheap, pumpable, and accessible. When the Navajo Nation steps up, they discuss that right now their 165,000 residents, many of them are rationed to less than 7 gallons a day. This is a big deal. We need to be paying attention. Go to pbs.org, go to the Supreme Court, get the transcript, listen to the audio stream, hear how groundwater is being impacted. For this week's feature story, I need you to go to pbs.org and listen to the oral arguments for the Navajo Nation versus the United States government that is talking about water rights for their 165,000 residents. But before we can jump into this feature, we need to understand a couple things that they're talking about. And if you go to the transcript or you listen to the 2.5 hours, which is a big dedication of time, but I'm telling you, there's a lot. The United States Supreme Court, after Sackets versus the EPA, and the other groundwater cases that are going on, are becoming much more savvy and asking much more specific questions, not about surface water and what the Department of Interior are doing, but about groundwater. So for us to understand this, we have to start with the Winters case. The United States Supreme Court first recognized Indian reserved water rights in Winters versus the United States in 1908. Under the Winters Doctrine, when Congress reserved land, that's for a reservation that became a tribal nation, Congress also reserved water sufficient to fulfill the purpose of the reservation. Next, in the 1950s, Arizona sued California over allocation of the Colorado River water in a case that went directly to the United States Supreme Court. When this all came together, this is back to senior water rights holders. This is back to California going, nah, we're not going to submit a study or a plan with the other 7 compact states. We're going to go at it alone. As this case was happening, efforts by the Navajo and other tribes to join that suit or be represented by a special assistant attorney general were rejected by the Interior, which said it would press claims to water in the basin on behalf of the 25 tribes. Yet, on March 20th, the United States government stood up along with the representative of the state of Arizona and said, no. Only 5 of the tribes had claims to the rivers itself, and the Navajo was not among them in that case. In 1964, a decree assigning rights to the Colorado River water, the Supreme Court excluded the Little Colorado River, which is spoken about many times in this case. And therefore, the Navajo's claim for what is adjudication was never given. And for these water rights to come up, the Supreme Court has to recognize them. The Supreme Court said in 1964 with the decree that it would retain jurisdiction over the case for any future claims or modifications to these waters. The Navajo Nation wants enforceable affirmative duties to assess the tribal water needs, develop a plan to meet them, and then carry out that plan by building water supply infrastructure on the reservation. I'm going to start with the most pertinent quote. This is in the opening arguments of the lawyer, Mr. Liu, for the United States government. He states, just as the 1868 treaty didn't impose on the United States a duty to build roads or bridges or to harvest timber or to mine coal, the 1868 treaty didn't impose on the United States a duty to construct pipelines, pumps, or wells to deliver water. I want you to think about the infrastructure demands of 1868 Western United States. Those affirmative duties aren't part of the treaty. And because the government has never expressively accepted those duties, the Navajo Nation's breach of trust claim can't proceed. This is all based on the fact that there's a breach of trust, that there's not enough water to sustain agriculture and life in the reservation without releasing water from the Colorado. He goes on to say, this is not to say that the United States doesn't have a moral and political responsibility to address the Navajo Nation's water needs. As part of the general trust relationship, Congress and the executives have secured for the Navajo Nation hundreds of thousands of acre-feet of water and over $1 billion for infrastructure on the reservation. We just covered this. A lot of this money just came out with the federal infrastructure law. That's not 4 years ago. That's not 10 years ago. By the way, this entire discussion started in 2003, right as we started seeing, slowing of the amount of water coming through. 1868, 1908, we weren't worried about a shortage of water at that time. He goes on. And in exercising its own sovereignty, the Navajo Nation is free to develop its own infrastructure projects, including by drilling water to access the cheapest source of water on the reservation. Because groundwater is cheap. This is what we need to be paying attention to as an industry right now, how these legal discussions continue. First question comes from Justice Thomas out of this. Where else would water come from? Mr. Liu replies, there's plenty of sources on the Navajo reservation. So if we're talking about the particular region of the Navajo reservation that's at issue in this complaint, the most accessible source of water on the reservation is groundwater. There are aquifers that lie beneath the reservation, and there's no impediment to the Navajo Nation accessing those water sources today. I want you to think about what's going on with Ogallala. I want you to think about the Edwards in the Trinity and the state of Michigan having 70% of their residents in drought conditions, and how we can't figure out how to sustain life responsibly with the amount of water we're using. He goes on, in fact, they're doing it across other parts of the reservation. Another source of possible water for this region is the upper basin, the Colorado River in the upper basin. The upper basin's come up with plans, everybody. The upper basin is trying to figure out how to backfeed the Salt Lake. There's so much going on here. He does say, however, the upper basin is farther away. Next, Justice Alito. Mr. Liu, I think you said that the Navajo Nation has hundreds of thousands of acre-feet of water. Is that correct? Lawyer Liu. Correct, Justice Alito. Justice Alito, do you have a figure for how much water that is? Lawyer Liu. It is, well, an acre-feet. It's how much water would fill up an acre of land. 1 foot. Justice Alito, right. Alito. But do you know how many hundreds of thousands of gallons? Do you know the amount of, can the United States calculate, or could you calculate water per capita? Lawyer Liu. I don't have water per capita, but to give you some example, the San Joaquin settlement in New Mexico provides 37,000 acre-feet annually. This covers 250,000 people over a 40-year time horizon. The appropriations associated with that are $1.9 billion. We're comparing 250,000 residents to 160,552 residents of the Navajo Nation who are limited to 7 gallons a day in places that we don't have access to water, that we as a nation determine this is the place that they can set up and continue to have a sovereign nation. Again, Justice Alito. So if we're looking at the expectations of the treaty parties, do we look at what their expectations would have been in 1868 or at the time of the expansion of the reservation subsequently? Lawyer Lou. We look to the 1868 timeframe, and in that timeframe, what they were thinking about was the land set aside from the original reservation, not the land that is issued today. You to think about the drought we're in right now and the impact that this is. Again, Justice Alito. Where would they have accessed water in 1868? Lawyer Lou. In 1868, the original reservation, much of that area lies within the Little Colorado River Basin. And there were washes that come from the main Little Colorado River that would have been a source of water. There was groundwater. They could have impounded water. So, you know, springs, washes, and wells. Then I want us to jump to the opening arguments for the Navajo Nation. And it starts with the Senate ratified 2 treaties with the Navajo Nation in 1868. The United States promised the Navajo Nation a permanent homeland. Both parties understood that in promising the Navajo their land, the United States was also promising them water in it needed to sustain life in the arid Southwest. Those treaties are specific sources of law that give the nation rights to water and impose duties on the government to secure that water. But for years, the United States has failed to fulfill that promise. Today, the average person of the Navajo reservation uses just 7 gallons of water a day. The national average, according to this right here, says 80 to 100 gallons a day. I want you to go back to our episode where we talked about general consumption. I want you to go back to that thought about, as we're standing in front of the Supreme Court and having a discussion about an acre feet, that we've determined 1 acre foot is good for about 3 households. You know, that a family consumes 110 gallons a day. And that we broke it down that people in Malai used less than 7 gallons a day, not in the United States of America. The U.S. agrees that on paper, the nation has treaty rights to water people needs. We're here because the United States says it doesn't have to do anything to secure the water it promised. Out of the gate, the first question that comes back to groundwater comes from Justice Jackson. But the tribes can't sue you if they think you're not up to the task with respect to that. She's referring to when they stepped in and said that the United States government and Arizona versus California, the U.S. government would represent the 25 tribal nations. Lawyer Lou, unless Congress has expressly assumed those duties, and in Mitchell 2nd, with respect to timber, Congress did. That is the case where they determined that Congress would say who had the rights to the timber rights. Congress enacted statutes that said not only would the timber be held in trust, but that trust is going to bear the hallmarks of a conventional fiduciary relationship. Justice Jackson again. And didn't our analysis in Mitchell 2nd really also focus on the degree to which the government assumed elaborate control over the forest? It wasn't so much just the language of the statute, but the government was acting as though it was controlling the forest in a way that is similar, I think, to what's happening here. Go listen. As I'm filming this right now, in the morning, I'll be meeting with NGWA members and I'm in DC. Obviously, when we're out for a week with the newscast, sometimes things get filmed before everything's out. But it is very important that we go, we check this out, we look at the discussions on water, look at what Justice Kavanaugh had to say, what Barrett had to say. It's a big deal, and they're getting very groundwater savvy and water rights savvy, which we need in the highest court of the nation. But we also need to understand sovereign water rights to tribal nations should be senior water rights. We need to be advocating for this. And we need to be talking about the degree of difficulty it is to drill in the Western United States, and how much investment are we going to put into that infrastructure? It's all very important questions. Can't have the ability to have a tribal nation that can raise agriculture, but doesn't have enough water to feed its people. You can't live on the homestead and farm it without water. It's a lot to think about. Thank you for watching, listening to episode 54 of the Driller Newscast. Next week, we will have a recap of the National Groundwater Smart Policies Fly-In. I'm going to meet with the Department of Energy. There's going to be a lot of exciting news that come out of this event. Our voice is important. The voice of sovereign tribal nations is important. Water rights and all American citizens' ability to access clean water is just as important as us being able to feed our country and the world, continue industry, everything that we have to do. And smart water policies is the tippy top of this discussion. Check out thedriller.com. Check out what we're doing in the social media. Thanks. Have a great week.